Hello everybody, this is just a very quick lesson giving us an indication of what the next series of videos is going to entail. This is of course in relation to the law of contracts, which we are still talking about. And we're moving on to topic 3 now, which is the topic that concerns bringing a contract to an end, the ending of contractual obligations, and the various different ways that this can be achieved in the law. So this is the next chapter on the subject of contract law, talking in great detail about the various circumstances in which a contract may come to an end. Now, this will be through a variety of different means, through either void or voidability criteria, by discharge of your contractual obligations, through duress in the creation of a contract, mistake, misrepresentation, and undue influence, all of which are different processes by which we can actually bring contractual obligations to an end. Essentially, what we're going to talk about first are what are known as vitiating factors. Vitiating factors are influences which may invalidate a contract despite the fact that, legally speaking, the contract may still be valid. So even though there is the contract is still legally valid, it is still legally binding, and on paper it still exists, they are vitiating factors in the sense that they are invalidating a contract. Next, we will then start talking about a number of doctrines in both common law and within equity, namely focusing on the idea of duress and undue influence and how this can actually lead to the voidability of a contract as well. Again, these are also situations which may bring a contract to an end. And then finally, we will talk about the discharge of a contract through various different means. So the scope of the next few lessons, at least the next 10 to 20 lessons, in fact, talking about bringing contracts to an end, will look a little bit as follows. We'll begin, as I've said, by looking at vitiating factors. These include the misrepresentation and mistake, as well as illegality. These are the three main factors in relation to vitiating a contract. You then will spend a little bit of time talking about duress and undue influence, and then finally we will talk about the discharge of a contract. This can either be done through performance, agreement, breach, or frustration. These are all of the considerations that we have to make for when contracts are brought to an end.